If you're an individual inventor and filing one of your first 5 patent applications, it's very likely that you're entitled to an 80% discount in the U.S. Patent Office. The government gives huge discounts to small businesses and individual inventors, but determining who qualifies for which discount can be a bit confusing. And if you pay the wrong fee and claim the wrong status, your patent could be invalidated. In this video, I'm going to explain the differences between large entities, small entities, and micro entities, and how you can qualify for the biggest discount. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. There are 3 categories of fees that are paid to the Patent Office when dealing with patent applications and patents. There are large entities, there are small entities, and there are micro entities. Now, as you might expect, large entities are big companies. These are often public companies. They're companies with more than 500 employees. The basic patent fee structure is calibrated around the fees that are paid by companies with large entity status. Large entity status is the default fee structure for the Patent Office. The second category, right below large entity, is small entity. Now, small entities are entitled to a 60% discount from the large entity fees in the Patent Office. There are 2 requirements to be classified as a small entity. First of all, you must be an individual or a small business with fewer than 500 employees or a nonprofit organization. And the second requirement is that you cannot have assigned or transferred rights or be under an obligation to transfer rights to a non-small entity. Now, this seems pretty straightforward, 2 relatively simple requirements, but like everything else related to the government, it seems, there's a lot of nuance with respect to the definitions in these requirements. First of all, in order to qualify for small entity status, every inventor on the application must be a small entity. For example, if engineers from 2 companies get together and one company is a small entity and the other company is a large entity, then the patent application they filed would be filed as a large entity. In order to qualify as a small entity, all of the inventors must qualify as small entities. Now, a second point to keep in mind is that there are no geographical limitations with respect to the definition of small entity. You or your small business can be located anywhere in the world and still qualify as a small entity with respect to the payment of patent fees. Now, the definition of a nonprofit with respect to the U.S. Patent Code is the same as the definition under the IRS tax code. So a company that's a 501c3 organization under the tax code would also qualify as a nonprofit under the patent code. Likewise, if you qualify as a nonprofit under state statute, you also would qualify under the patent code. And if you're a foreign nonprofit, you're also eligible for small entity status, so long as you would be classified as a nonprofit under U.S. law if you were located in the U.S. Now, reminding ourselves that the 2 requirements for qualifying for small entity status under the patent code are that number 1, you must be an individual or small business with fewer than 500 employees or a nonprofit, and there's no transfer or assignment of rights or no obligation to transfer or assign rights in the invention to a non-small entity. Now, it's important to understand the difference between an invention and a product embodying the invention when considering the transfer of invention rights. It's the transfer or assignment of rights in the invention to a non-small entity that could trigger the loss of small entity status, and it's not the transfer or sale of a product embodying the invention. Let's take a look at a hypothetical that'll help us understand the distinction between licensing an invention and licensing a product containing the invention. You've invented an app for the Android phone that lets cafeteria and restaurant owners lay out and print menus of their meals. You upload your app to the Android store, and the head of food services from Google sees your app and downloads it and uses it to produce lunchroom menus for Google cafeterias. Now, the food services manager arranges for Google to pay you the $9.95 a month or whatever it is you charge for your app. And in essence, Google is licensing this product from you through its download from the Android store. Now, let's say you file a patent application onto the underlying technology embodied in the program. And even though Google has licensed the product from you, they have not licensed the underlying invention, the underlying technology. And therefore, assuming you qualify as a small entity status applicant, you don't lose your small entity status because of this license, this product license to Google. Now let's take a look at a second hypothetical. Let's say you've invented an automatic transmission for a bicycle. Trek Bicycle Corporation sees your automatic transmission and decides they'd like to incorporate this automatic transmission in one of their lines of mountain bikes. Now, they don't want to buy automatic transmissions from you directly. What they would like to do is license the patent so that they can manufacture and sell bicycles containing the automatic transmission. Now, assuming that you do this deal with Trek, in transferring patent rights to Trek for the manufacture and sale of the automatic transmissions, to the extent that you had small entity status prior to the deal, you lose the small entity status when you transfer rights in that patent to the large entity Trek. So the distinction here is that it's not the product that you're selling to a large entity, but rather it's rights in the patent that you're transferring from your company to the large entity, which triggers the loss of small entity status. And it's also important to understand that you've only lost small entity status rights with respect to that patent that's been transferred. And if you have other patents that have not been transferred to Trek, those patents may still be eligible for payment as a small entity. Now, a couple of final points with respect to the payment of small entity versus large entity fees. If you're a small entity and you hire that 500th employee and you become a large entity, then the payment of fees changes at that point from small entity to large entity. You don't need to go back and pay back fees as a large entity on fees paid prior to the change in status. And the second point that sometimes comes up is the oh dear me, where you realize that you should have been paying large entity status on an application when in fact you've been paying small entity fees. In this case, you just notify the patent office that you unintentionally and inadvertently paid the wrong fees, and the patent office will allow you to go back and correct the fees and pay the correct fees for past payments. Now, we've talked about large entity, we've talked about small entity. Now let's talk about micro entity. Now, as a small entity, you're entitled to a 60% discount off the large entity fees. As a micro entity, you're entitled to an 80% discount off the large entity fees. So how do you qualify as a micro entity? Now, there are 4 requirements for determining micro entity status. The first requirement is that you must qualify as a small entity. The second requirement is that you must not have been named as an inventor on more than 4 prior patent applications. The third requirement is that your annual gross income in the prior calendar year must not be more than 3 times the average household income in the U.S. for the prior calendar year. Now, at the time of this filming, that threshold is set at $212,000. And the fourth requirement is that the applicant has not assigned or transferred rights in the invention to any entity which exceeds the threshold income, other than a nonprofit or an institute of higher education. Now, there is an exception to the income threshold for microentity status for those persons whose majority of their income comes from institutions of higher education. Now, to qualify for this exception, you must have transferred or have an obligation to transfer at least some of the patent rights in the invention to an institute of higher education. Now, the Patent Office specifically points out that they're watching out for scams and shams around this microentity exception. So if you're going to claim this exception, you may want to consult an attorney first. One final note with respect to claiming microentity status in the Patent Office is that applicants are required to fill out a form attesting to their annual gross income. This form is the SB/15A. And if you're wanting to qualify under the university exception, then you'll fill out the SB/15B form. There's a lot to this determination of large entity versus small entity versus microentity status. I've tried to hit the high points, but if you have a comment or question, leave them in the discussion section below and I'll try to answer any questions that come up. And if you'd like some help protecting your invention or your IP and would like to consult with an attorney, give me a call or send me an email message at the address below. In the meantime, I think you'll like this next video. I'll see you over there.